do opening statements from each of the candidates now. They will have 10 minutes. As we discussed with the candidates, this is your 3-minute warning, and this is the stop. And I told them that the first time I appeared for the head of the Supreme Court, they'll be sure to tell me, Mr. Gill, please sit down. With that, we're going to go in alphabetical order for the openings, and then we'll do reverse alphabetical order for the closings. So, Ms. Brody, you're first. Thank you.
The Idaho Constitution empowers us to actually elect the justices who sit on our Supreme Court. It's a much different system than anything that we see here in the United States as a whole. It's a system that is fundamental to what we do. And in recent years, there have been a lot of discussions. Should we have judicial elections? What should those judicial elections look like? I know after participating in this process, and as I look at the other candidates who are here and the broad background we bring, I can't help but think that this is exactly what our forefathers had in mind for the democratic process of electing our Supreme Court justices. Before we make any serious move about changing our system, I think it's important to consider what Thomas Jefferson once wrote. He said, "I know of no safe depository for the ultimate powers of the society other than in the people themselves." If we think them not enlightened to exercise their control in wholesome discretion, the remedy is not to take it away, but rather to inform their discretion by education. I have one purpose here this afternoon, and that's to educate Idaho's voters about who I am, my judicial philosophy, and why I'm the best candidate for the Idaho Supreme Court. Now, starting law school, like I'm sure most of you, I had a plan. I knew everything. I was 23 years old. I was working as a Russian translator for the world's largest uranium broker at that time. I was enrolled in a dual degree program. I was going to get my law degree. I was going to get a master's in international management, and I was headed back to St. Petersburg, where I had just left. Those were my intentions. What I didn't plan on was falling in love. Falling in love with a beautiful man who has Idaho in his heart, and falling in love with the law. For me, researching, writing, debating the law, it was everything that I wanted to do. It spoke to my heart. I wasn't on the mock trial team. I was on the traveling appellate team. It's what made my heart sing. Now, out of law school, I have to tell you, I feel so blessed to have been delivered to the doorsteps of Hepworth, Lathamis, and Honthorst in Twin Falls. Some of you know those men, and you know, I tell people who don't know them that they were the John Elways of the Idaho legal community. I'd like to think, two of them are gone now, and I'd like to think that I carry a little bit of each one of them with me as I practice law today. John Hepworth's grace, his compassion, John Lathami's fire and determination, and John Honthorst's keen legal mind and his sense of professionalism and collegialism. Those are the things that I carry with me. I practiced with them for 13 years. I had one foot firmly planted in the litigation world and the other firmly planted in the business world. In 2010, I made a very difficult decision to leave my practice with the firm. My mom had breast cancer and we had 2 little boys, and I was commuting to Rupert. And so I made the decision to open up my own firm in Rupert, where I've been ever since. I have what I consider to be a small town practice, but frankly, with some big city services. I represent the widow who walks in the door needing a marriage license from Salt Lake City. I represent the person who needs Social Security disability. But just last week, I also closed a $3.5 million real estate deal that will bring a Federal Express cargo facility to the Twin Falls Airport. Those are the kinds of things that I do in my practice. I represent farmers, ranchers, business people. I represent school districts, our local hospital. I represent community health centers in Glens Ferry and Bruno. Those are the kinds of people that I represent. Now, in terms of judicial philosophy, I have to tell you that I believe the role of the Supreme Court justice, the ideal one, is one that exercises great restraint, punctuated by moments of great bravery. And let me explain what I mean. When I talk about great restraint, it is imperative that we understand the separation of powers. The fact that the Idaho judiciary is not the legislative body. No matter how much I'd like to tell our legislature the laws that I think should be passed, that's not the role of the judiciary, and we have to honor that separation. But at the same time, I think it's imperative that when the Idaho legislature oversteps its bounds, that we recognize that at its core, it's about protecting individual freedoms, and we have to be willing as justices to stand up. I have never been afraid to climb in the foxhole with the people of Idaho. Whether it's taking on the Department of Transportation, or taking on the Department of Insurance, or the Bureau of Occupational Licensing, or the Bureau of Medicine, those are the kinds of fights that I'm talking about. It's about protecting people's freedoms. When we interpret the Constitution, we do it conservatively, with great care, giving life to the enduring principles that are written in the Constitution. Now, I know talking about Justice Scalia in mixed political company is a little bit dangerous, but the one thing that he did for our American jurisprudence is to bring the concept of originalist interpretation to the forefront. We now have, it doesn't matter the political leanings, we understand that originalist interpretation, even if you're Emil Amar from Yale, or Jim Balkin from Yale, or Justice Kagan, that the originalist approach is the right conservative approach to interpreting the United States Constitution. Now let me tell you what makes me the best candidate for this court. Representing the people and being connected to the people is so critical to the decision-making that goes on in our courts. And it's something that makes me different from the other candidates that are here. The other thing that makes me different from these candidates is having the rural perspective. Now, I'm not an Idaho native daughter, but I'll tell you, I feel so at home in Rupert. The first vehicle I ever drove was my grandfather's tractor, and I know that's probably the same for a lot of you. But having that rural perspective is so important. It's important in terms of the decisions that we make, but it's also important in terms of court management. I know from living in Minidoka County that a one-size-fits-all approach to court administration and court management doesn't work. Not when you live in places that don't even have voicemail yet for some of their court systems. The rural perspective is important. I speak rural Idaho, and sometimes just when it comes to management, and remember, a big part of what the court does is people management, managing the system. Sometimes it's just having the right person at the right time with the right words to say the right thing. We have such an important task ahead of us in terms of implementing the I-Court system and the portal. We see it at work in Twin Falls, but we've got 43 more counties to go. And I think having a person that has energy and a willingness to connect with people makes a huge difference in terms of court management. And frankly, maybe I'd like to take a little bit of our small town values and spread them around. I'm a person that likes to say yes when I can rather than no. I'm a person that likes to say accommodate rather than give an attitude of inconvenience. And I think that's what I'd like to see in our court system statewide. Now, as we move forward, there are so many tasks ahead of us. I can tell you that from my perspective, people ask me, why the Supreme Court? Why not the Supreme Court? In my world, I feel like I was made for the job. Maybe in your life you would call it a vocation or a calling. Whatever word you use, it fits. It fits me. I started my courtship with my husband at the DU Law Library on a Friday night. There's nothing better to me than a Supreme Court argument or a court argument where the judge is prepared and wants to talk about the law, where they want to discuss what the law should be. Now, hopefully, I have the opportunity to earn your vote. And if I do, I'd like you to help me spread the word, to help educate Idaho's voters, to get on my website, to like it, to like the Facebook page, and help me educate Idaho's voters. Thank you.
Justice Gutierrez.
Good afternoon to those present here at the Idaho Law and Justice Learning Center, and to all those viewing by Streamline. I want to say a special good afternoon to those little ones that I saw that ought to be in school perhaps, or maybe they're out of school already, but thank you for being here. And thank you all for your interest in this important election. I'm honored to participate in this event, which I believe may be the first of its kind held in this venue. It is particularly satisfying for me to be here, as I was among those invited by former U of I College of Law Dean Donald Burnett to convene and explore possible uses of this building, which many of you know was once the Ada County Courthouse. I remember sharing with that group the experience of my visit to the United States Constitutional Center in Philadelphia and discussing the importance of establishing a place where civic education could be a priority. I'm glad it has been realized. I would also like to thank the sponsoring organizations for their work to provide this opportunity for a dialogue. The Idaho women lawyers played an important role in my initial appointment to the district bench over 20 years ago. More specifically, former Justice Kathy Seilig mentored me through that process, which, as some of you know, is quite involved. As to the appellate section, I have good memories of talking with the founders about my experience in petitioning the bar commissioners, along with Richard Boardman, to create the diversity section. And I'm glad to hear that the appellate section now has over 100 members. Great. My connection to the litigation section is one of ongoing gratitude, as they have contributed financially to what is now its 5th year of success, our diversity section high school pipeline program, Love the Law. I begin my remarks in this way not only to thank this evening's sponsors, but to begin to impress upon you my chief qualifications for a seat on the Idaho Supreme Court. The depth and breadth of my experience in these instances as a leader in the legal community. Remember that the position of Supreme Court Justice has responsibility that goes beyond that of resolving cases on appeal. It is responsible for oversight and improvement of our entire court justice system, something that cannot be overlooked. My experience in that regard also includes chairmanship of the Idaho Supreme Court's Fairness and Equality Committee, as well as the Idaho Supreme Court's Language Access Committee. I have served as co-chair of the Idaho Supreme Court's Judicial Recruitment Committee and have been a member of the Governor's Criminal Justice Commission as well. So I'm experienced not only with the inner workings of judicial administration, but also with the mechanics of actually achieving meaningful system-wide improvements. As already mentioned, I also have over 20 years of experience as a sitting judge. I was appointed to the District Court by Governor Cecil Andrus and appointed to the Court of Appeals by Governor Dirk Kempthorne. I emphasize the role of these men played in my judicial career because although they may have had different political views about many things, they each understood and valued the importance of an independent and nonpartisan judiciary. These public servants did not select me in hopes that I would rule in certain ways on certain cases, but because they were confident that I would follow the rule of law and fairly apply it to each case regardless of convenience or popularity. My record of decisions proves that their confidence in me in such regard was justified. Of the many things I learned as a district judge, one of the most valuable lessons I was grateful came from an unexpected place. The victim in a case I was presiding over. It was in my early years as a 3rd Judicial District Judge that I was introduced to the restorative justice approach. I was riding the circuit, handling some cases in Emmett. One particular case dealt with malicious injury to property charges arising out of destruction of some farm equipment by two young men. Perhaps some of you have been to the courthouse in Emmett and will recall that it is a little older style construct with not much space between the actual judge's bench and the public seating area. After hearing the recommendation from the deputy prosecutor and defense counsel, I proceeded to announce my sentence. And no sooner had I made the announcement than a hand rose up from the back waving assertively. It was out of the ordinary to have someone in the gallery interpose themselves in the court proceedings. A tall gentleman stood up, and I asked, "What can I help you with, sir?" The gentleman responded, "Judge, don't you think you're being a bit too harsh on these young boys?" As I inquired further, I discovered he was a farmer involved in the case. He requested I reconsider my sentence and allow the young men to work on the farm to pay off the damages. This man's suggestion, along with Senior Magistrate John Barron and his work with the Juvenile Justice Projects, inspired and guided me to learn more about turning the courtroom into a place of healing. I believe that being a judge involves listening to people and learning from them whenever possible. While at the Court of Appeals, I've had the privilege of learning from some of the best judges, including now retired judges Darrell Perry, Karen Lansing, and former justices Gerald Schroeder, Wayne Kidwell, and Jess Walters, and the man I replaced on the court, Alan Schwartzman. Each of these jurors had a style reflecting their own personality, but each of them was passionate about rendering opinions that reflected fairness and independence. Our relationships were committed to respect for each other's views and for acting always with the greater public good in mind. That is the style my experience allows me to bring to the Idaho Supreme Court. Of additional relevance in terms of the value of my experience to the court is my personal life experience. In that regard, my experience is that of an illegitimate child born into poverty and dysfunction, an immigrant to this great country, a high school dropout who has known both hunger and homelessness. My experience is also that of a Job Corps graduate and of a father and grandfather who understands that the American dream is not about achievement so much as opportunity. I deeply believe this to be true, that those who are called to sit in judgment with a seat on Idaho's highest court must be experienced not only in the law, but in the many paths a life can take. My path began in Mexico. I was brought here by my parents and believed that after the gift of life, their decision to head to the United States was perhaps their greatest gift to me. They came in search of a new start, in search of, though they would not have articulated such, the American dream. The seeds they planted with that decision proved to bear for me the sweetest of fruits, the fruit of opportunity, the fruit of democracy, fruit whose juice now runs in my veins surely as the blood of my ancestors. My family settled in the San Joaquin Valley in California, where my father worked as a farm laborer. Our existence was a meager one, and as my mother's emotional health deteriorated, my younger sister Dina and I were sent to live with my grandmother in Carlsbad, New Mexico. My memories of those days are of happiness despite hardship. We lived in a shack and lived on government-issued cans of powdered milk and potted meat, and it is not difficult for me to remember even now the smell and taste of that food. Though poor in material possessions, we were rich in love, and that gave me a good start in life. Fast forward, if you will. Despite many other challenges, I went to college and then to law school. I practiced law for several years and became a district court judge. From there, I was appointed to the Idaho Court of Appeals. I was, and am the only Latino judge in the state. Because of that, today some people see me as a symbol of progress, and that is my burden and also my honor. Now I stand for election as an independent, experienced judge with a record of fairness who will bring also a diverse life experience to the court. Thank you.
Thank you, and thank you for being here. My background is a little bit different than the other candidates. I came to Idaho to go to Northwest Nazarene College, college back then. I was a physics and history major, played soccer and was on the track team, and didn't go there necessarily by choice, but I had planned to go to the Naval Academy, and the Navy just had other plans for me. So I came to Nampa, and my parents had gone there, and I've got three brothers who also have gone to NNU. And after my first 2 years there, my parents have been helping out with me paying for school. They couldn't do it anymore. So I took a year off. I worked at IBM in Bethesda helping a software development group. Saved my money, went back to NNU, graduated magna cum laude without any debt, with no student loans. And from there, went to Georgetown University on a full tuition scholarship. There took tax law, studied intellectual property law. And one of the opportunities that I had was from my constitutional law professor, who was friends with Justice Scalia, who came and spoke to our constitutional law class, and we had the opportunity to ask him questions. I didn't ask him about constructionalism or textualism. I asked him what the difference was between serving on the U.S. Supreme Court as opposed to the Court of Appeals for D.C., because in a sense, in the Court of Appeals, you're either applying precedent or trying to guess what the court over you would rule, whereas on the U.S. Supreme Court, you are making that law with each decision. And basically, he kind of had an exasperated look and just said, you can't reinvent the wheel with every case, it's kind of the way he grilled people when he was on the bench. And one of the things I could do from school is I would walk over and sit, and if it wasn't a controversial case at the Supreme Court, the public could go in and watch them hear cases. The law school wasn't on the campus. The beautiful campus over in Georgetown is right near Capitol Hill, and so I could go and watch them hear cases, which was fascinating, and gave me the dream of one day wanting to be on the judiciary, but at the time it was just a dream. I didn't think it would be something that I would ever get to fulfill. I was on a trial team, was an editor for The Tax Lawyer, which was, I think, the only student journal that was co-published with the American Bar Association. And after law school, went to work for a firm in Washington, D.C. I was in the top 10% of my class. And we did what we call soft IP work, trademarks, copyrights. We did protection for the U.S. Olympic Committee, for Major League Soccer, wrote up licensing agreements. And also did a civil appellate practice where I did a lot of writing under the supervision of a partner who was very fair but critical of our work, and so I think I developed as a much better writer through that experience. It was also a very hour-driven firm, and my first son was born while I was there and had to make the decision of whether I was going to stay in D.C. And work for that firm or another firm, or come back to Idaho, and I just did not want to raise a family there. And so we came back, and I became deputy prosecutor with Ada County. This was out when we were out at Barrister. So if anybody remembers, I think we had the last non-attorney magistrate out there at Barrister, the last one that became an attorney after she was appointed. Did a lot of trials there. From that practice and my civil practice, since then I've gone to verdict in over 20 jury trials, which I think is an important perspective to have for a judge. especially an appellate judge, because the split-second decisions that you have to make in trial, it's good to have the perspective of that. From there, I went to work at Stoll Reeves. See a few of my friends here from Stoll Reeves. We did a complex civil litigation practice. I was in the litigation group. Was there about 6 years, and then started my own firm and work with one other attorney now. And as owning a sole practice, if those of you who do, you understand what it's like to make a payroll. Some months when my employees got paid and I didn't, especially when we were in session, and I was divided between my office and being in the Senate. But I think it was an important perspective to have. That diversity of practice that I've had from large firms to having a sole practice doing intellectual property and civil litigation and criminal law, I think is also an important background to have because of the number and variety of issues that come before the court. During that time, I also served in the state Senate. I was there 7 terms, chaired state affairs. As part of that service, I'm currently the president of the Pacific Northwest Economic Region, which represents the Pacific Northwest states and the western provinces and territories. We work on issues such as invasive species. You may have heard of quagga and zebra mussels. Hopefully you haven't. We're the only region in the country that doesn't have them. The Columbia River Basin doesn't have those, and we've been working to get Congress to help us provide matching funds to man our stations at our borders to catch boats. We've gone back to Congress to deal with the Columbia River Basin Treaty, which is up for renegotiation, and worked on things like that. In addition, I've worked on the Public Defender Reform Committee. We just came out with our recommendations over the last couple of years. I think that's a very important step for Idaho, going away from the model where they would send out a flat fee contract to more of an hourly type contract with some parameters, and so that people are getting adequate representation when they go through the court system. I think that's very important. Outside of the legislature, I've been on the board of Love Inc. of the Treasure Valley, which you may be familiar with. It helps people with emergencies and also helps them redirect their life, kind of get back on top of their debts. And also I've been on the board of directors for Syringa House, which was part of the Northwest Children's Home. They had a girls' home in Nampa until just recently. I decided to run for the court because the timing seemed right with Justice Jones retiring. I planned to run for the Senate for one more term and be done, but I realized the dream that I had back in law school was something that if I wanted to make it real, I needed to act. We don't always get to choose the moments in life, but we do need to act when they come, and so I'm proud to run. I think we've got great candidates. I think I bring a different perspective and background because of the diversity of practices that I've had, and I think it's a good one. I think I'd serve you well in the court, and so thank you for your attendance.
Mr. Strong.
Thank you. It's a pleasure to be here this morning. I'd like to thank those that are sponsoring the event today. It's a very good opportunity for us to express our views to you, the constituents. I'd like to start off with the thought that what's really unusual about a judicial race is what Justice Jones mentioned, is that typically when you're in an election, the process is to advocate your position, your points of view. But when you're in a judicial election, we want just the opposite. We don't want you to talk about your point of view, but rather to articulate why the public should invest trust in you. And I think it's important to have the election process so that you can get an opportunity to get to know us each as individuals. Because unlike the other offices, you're entrusting to whoever is appointed or elected to the Supreme Court the responsibility of being fair and just. And that can only happen if you understand the background and character of the individuals. It's important to look at the election process itself. As I got into this race, I began to look at just how people go about electing judges. And what I found is something that's very unusual. Not only have we seen a drop-off in the number of people that are participating in the election, but from the top of the ballot to the bottom of the ballot, 40% of the people don't vote in the judicial elections because they don't know the candidates. And I applaud you for being out here this morning, or this afternoon, excuse me, this afternoon to hear from us about why we believe that we, each of us, are the best candidate for the Supreme Court. My interest in serving on the Supreme Court really goes back to my passion and commitment to public service. And that passion and commitment has been expressed over the last 33 years as I have served in the office of the Attorney General. I came to that position in a natural way. As a youth, I had a passion for natural resources. I grew up in Wendell, Idaho, a self-described hub city of Magic Valley. And in that capacity, I, as Justice Gutierrez, grew up in a family that knew poverty. We oftentimes didn't know where our next meal would come from or how we would pay the utility bills. But even though we came from that setting, I came from a setting in which it was a very rich family, in which I learned values from my mother and my father. My father taught me hard work. He taught me a commitment to the community. My mother was committed to helping us have a better life as we move forward. And she had diabetes, and as a diabetic, she had significant problems with insulin. But nonetheless, despite those challenges, she was there with us every night as we went forward and tried to get our studies so that we could become more successful citizens as we move forward. And we learned that as part of a family, we all had to pitch in and help. And so I learned values of honesty, integrity, and trust from my family. But as I moved forward, I also realized that there was other opportunities out there, opportunities for me to succeed, and that would require my commitment to gaining the financial resources necessary to get myself through college. And as I did so, I saw the opportunity as a citizen of Idaho to go to the University of Idaho and obtain an undergraduate degree in forestry. And at the time I was getting that degree, it was apparent to me that there was an opportunity as well to combine my interest in the natural resources with law. One of the very difficult issues we as attorneys and practitioners and judges deal with is this integration of law and science. Science is about trying to prove a hypothesis. Law is about trying to prove an absolute certainty. The two don't necessarily meet, and so it's important to understand how the relationship of those two work. And so it's from that background that I decided that I could serve best in a public setting because I understood both sides of the points of view. And so as I moved forward in my career, I joined the Office of the Attorney General. And in that capacity, had the opportunity to work on some of the most important and most significant issues that have confronted the state of Idaho over the last 30 years. My third day in the Office of the Attorney General, I was assigned the Swan Falls case, a case in which the very essence of Idaho was at stake. The issue of whether the power company or the state would control the waters of the Snake River Basin. We had received a decision from the Supreme Court, a decision that in my mind, we respectfully disagree with the court as to its conclusion. But nonetheless, it was the law that we had to deal with. And so from that perspective, I was given the challenge of trying to resolve that dispute and put the state back in the role of being able to regulate and administer that resource. And we were successful after a very long and difficult battle to reach a resolution of that issue, which then led to the Snake River Basin adjudication. And in the Snake River Basin adjudication, we spent 27 years adjudicating 158,000 water rights. Think about that. When Justice Scalia did the closing ceremony, what he observed was that was equivalent of doing one claim every 90 minutes, 24/7, for 27 years. Now, that's the largest case that the state of Idaho has ever handled. And we're the only state that has successfully completed that type of adjudication. And in the process of doing that, I was in the lead role for the state. I was in the capacity of trying to define and establish procedures that we could use to process a case of that magnitude. We learned how to streamline the process. We began imaging of documents back in 1990, what the court is just now beginning to do. we began developing processes to help facilitate pro se participation in the adjudication. So many of the things that we're grappling with today are the very issues that we confronted in the Snake River Basin adjudication, and our experiences, I believe, I could bring to the court to help facilitate the administration of justice. But not only that, I also had the opportunity through that process to work both in negotiations and litigation. From a negotiation standpoint, I was the one that was in the middle, the facilitator trying to bring the parties together, and we were successful in resolving all 3 Native American water right claims in the Snake River Basin adjudication in a way that recognized and respected the rights of the Native Americans, and at the same time protected the interests of the individual citizens of the state. So I've worked in the trenches. I understand the local interests. I've worked throughout this state to bring those issues to conclusion. In addition to working on those large settlements, I've also had the opportunity to litigate at the highest levels. I've litigated numerous cases before the Idaho Supreme Court, and I've litigated 2 cases before the United States Supreme Court dealing with state sovereignty. That has been a principal foundation of my practice, is to respect state sovereignty, but at the same time to do so in a way that recognizes and respects the rights of individuals throughout this great state of Idaho. So from my perspective, I would in summary say the things that I bring to the court is, one, that I have lived, worked, and learned throughout the state of Idaho. I understand the regional issues. I have also been in the capacity of having to understand and appreciate the respective interests of parties and tried to find a way to fashion the law to achieve an outcome that is just and fair for everyone. So from those perspectives, I would bring that kind of perspective to the court. And as a justice, I also understand the need and the importance of respecting separation of powers. I've litigated those issues. Those are real issues to me in which I've had to deal with a conflict between the judiciary and the legislature, and between the landlord and the legislature. Those are ones you want somebody who's battle tested. I've been there. I've done those issues. I know how to litigate those types of issues, and I think I can bring that experience to the court in a way that would benefit the citizens of the state of Idaho, and I would appreciate your support as I move forward. Thank you.
All right. Thank you all candidates for your opening remarks. We're now going to turn it over to Mark Johnson of Gallatin Public Affairs to lead our candidates through a question and answer session. If any of you have any questions you want me to hand up to Mr. Johnson, please do so.
Thank you, Clay. Thank you to you and to the State Bar and all those who had a hand in organizing this forum today for inviting me to participate and try to provide the questions for the candidates. What I'd like to do, at least initially to start here, is to pose a couple of questions and ask each of you to respond. And Ms. Brody, I'll ask you to begin first, and we'll kind of go in the same direction that we went with the opening statements, and then I'll reserve the moderator's prerogative to mix it up a little bit as we go forward. I would just add, obviously, the shorter your answers, the more questions we'll have an opportunity to get to. Don't make me be Antonin Scalia and cut you off. That's another way of saying that. For each of you, I'd like you to describe for us how you see the job of being a judge. Are you a referee? Or as Chief Justice Roberts famously said, the job of an appellate court judge is to call balls and strikes. What is the job of a judge? How would you describe it, Ms. Brody?
I think Judge Ryan said it best. It's the trial court's job to make a decision, and it's the appellate court's job to get it right. I think you've got to take the time, you've got to think about it, deliberate, consider it, chew on it, whatever you want to say. That's the role of the appellate courts.
Judge, how would you describe your job as a judge?
Probably my example would be to use the trial judge as one who's flying the spacecraft out into the universe beyond our world here, and having to maintain all those controls. As a trial judge, you're having to act on the spot, make decisions. The appellate judge really is more like a surgeon, that it has to limit itself in how it uses the law and applies the law to a specific case, and so carefully and disciplined and applying it fairly.
Mr. McKenzie.
I think the role of the court is to fairly and impartially apply the law to the fact pattern that comes up from the court. As the trial judge is either the fact finder or overseeing the jury as they find the facts. So he's got a dual role of both the fact finder and applying the law to that. On the appellate level, you have that trial record that comes before you. So your role is to apply the law as it's written to that fact pattern.
Mr. Strong.
I would agree that the appellate court's role is to apply the law to the facts that are before you, but I think it's important to recognize that with each case that the court decides, it's creating a resolution not only of that particular case, but creating precedent for the future. So it's important that as the court issues its opinion, that it carefully considers that opinion so that it doesn't create unintended consequences, but does provide guidance for the future.
You all did a good job, I think, of describing your backgrounds and your experience in the law. This questioner from the audience says, given your past experience in the law, under what circumstances would you feel it necessary to recuse yourself from a case? Mr. McKenzie?
I think it's probably would start if it was a bill that I carried in committee or on the Senate floor, that would be something I would recuse myself. Otherwise, same standards that would apply for other justices. If I was close friends with a party or somehow involved with it, that would apply. But I think I'm somewhat unique that if one of those laws came forward that I had personally carried, I think that would be something that I would recuse myself on.
Mr. Strong?
I would concur in the sense that I would recuse myself in the sense if I had a relationship or a personal friendship with someone that was before the court, or if it is a case that I had been previously actively involved in.
Ms. Brody?
In addition to those reasons, I think it's important to look at constitutional limitations in terms of conflicts. I think it's important to really ask yourself, is there something about either my background or these people or this topic or this particular case that makes it so that I fundamentally cannot be fair to the parties involved? And I think you've got to really examine yourself in your own conscience. One of my favorite voir dire questions is would you want to, when someone asks a juror, would you want someone with your mindset sitting on this case? And I think that's the type of question that I would ask myself.
Judge, have you recused yourself?
Most of my recusals have come on cases that I sat in as a trial judge, and those are all long gone, so I have very little conflict in terms of hearing cases, but I would agree that in terms of relationships and interests and people that definitely I would have to recuse myself.
And Mr. Strong, I think I'm right when I say that Idaho is one of only 2 states that doesn't have a woman on its highest court or a person of color. Thinking about the judiciary broadly and the Supreme Court in particular, how important is diversity on the courts?
Well, I believe diversity is important and is a factor that should be considered in my practice of hiring deputy attorneys general in the office. It is a factor that I take into account, but I also take into account other aspects of diversity. Diversity in terms of experience, diversity in terms of interest, background, so that we get a broad array of input that allows us to better understand each other's points of view. So yes, I think it's an important issue, but I think it's one that's not just based upon gender or ethnicity, but also other factors of diversity as well.
Ms. Brody?
That's a tough question for me, since I'm the only one up here in a pink suit. And it's been almost 10 years since we've had a woman sitting on the bench. It's hard for me to remember that because when I started practicing law, Linda Koppeltraut was actually our Chief Justice. I've never been about my gender. You know, when I went to work for Hepworth, Lathamis, and Honhorst, I remember John Lathami sitting in the interview room with me, and he looked straight at me and he said, you know, now we don't want any more partners. It had nothing to do with gender. It just had to do with the structure of the firm. And I remember thinking to myself, note to self, they don't want any more partners. They made me a partner 3 years later, and I got to vote on my salary. I've always been about being the best, making myself the best lawyer that I can be. I've been about making, my philosophy as a lawyer is when a client walks in, I want them to be better off when they walk out my door. That's what's important to me. It's who is the best human being and who is the most qualified. That's my criteria.
Mr. McKenzie, the questions about the importance of diversity in the judiciary.
Yeah, and I think that's important, but to also include diversity of background, academic background, diversity of experience as an attorney, the types of practice, the types of cases. I think those are all important things to think about when we select a justice.
Judge Gutierrez?
Excellent question. I was a new district judge when Justice Linda Couple-Trout asked me to head the Fairness and Equality Committee. And it weighs heavy on me. When I became a judge in 1993, I thought, well, within 5 years, we'll see another Latino on the bench. I'm still waiting. And it's important in this sense is that it really impacts the integrity of the court, the court system. Imagine as a lawyer going to a jury and it not being reflective of your community. It's very simple. The public loses trust and confidence. What happens when you add diversity? I prefer to call it inclusion as opposed to diversity, and that is that you widen the lens of justice. And that is one of the reasons why I became a lawyer, as I got exposed to the law and more specifically got exposed to the conditions of our farm workers here in Idaho back in the 70s. And so I think it's important. I think you said there were 2 courts or 2 states.
I think that's correct.
It shouldn't be that way, period.
Mr. McKenzie, do you have a judicial role model that you could point to? And of former justices of the Idaho court, who do you particularly admire?
Well, I would say Justice Scalia, for the way he thought about cases. I don't think I would have the same personality when people were before me. It's not my nature to be that aggressive in questioning, but hopefully as aggressive in thought and bring the same type of understanding of the role of the court with respect to the written constitution and statutes. I think that's important. Justices, there's some that are sitting now. Did you ask me if they're sitting or?
I was going to let you off the hook by asking about former
yeah, well, I won't say. I'll just say that there.
You might have to go back up there sometime.
There's a number of justices that I admire that currently sit, but I won't mention their names.
Okay. Mr. Strong, judicial role model?
Well, I think in running for the court, the role model that we've got to be looking to is ourselves. Do we have the characteristics and the qualities that are necessary to be a fair justice? And so as I look at that, I think about, do I have those skill sets to do it? It's not necessarily that I want to have somebody else's role model. I want to make sure that I meet the criteria and qualifications that are necessary to do the job, and I believe I do. But if I were to point to someone, I would point to Justice Schroeder. Justice Schroeder is one that I've watched over the years and had a great admiration for.
Ms. Brody?
It would be Linda Couple-Trout, for sure. Her demeanor on the bench, I think, it was impeccable, and it's exactly what I think being a justice is all about.
Judge? Judicial role model?
Yeah, yes. I've always enjoyed Sandra Day O'Connor because she brought to life the judge in more than just the court. As you know, she's become very involved with civic education, and it's got a website and great programs to follow through. But what was important about the work that she did on the court, being the first woman on the Supreme Court, was that it was not about ideology. Many times she was in a deciding vote, and it was about reasoning. So where ideology and emotion hit a hard place, it was Sandra Day O'Connor who, in essence, would come out with that reasoning that would eventually carry the day for those decisions. And I would agree with Ms. Brody that I came onto the court when there was a change in our Chief Justice in our Idaho system, and it was very notable. And I believe it was because she brought a very different experience. And it was a historic moment in our history, our court system, because we grew in terms of being responsive to the public in a way that I don't think it would have happened had it not been for Justice Linda Koppeltraub.
Question to each of you about, we heard the Chief Justice talk about the restrictions on judicial candidates in terms of seeking the position that the four of you seek. I'm curious to go a little deeper into that question and ask each of you how you've structured your campaign effort. It seems like the judicial races inevitably have a campaign patina around them, but there are definite things that are not allowed candidates to do. So how have you structured? Do you have a campaign committee? How are you approaching going about seeking votes? Where are you making appearances? That sort of thing. That's what I'm interested in. Judge?
Well, the first thing I did is I made a copy of the information that we got from the Judicial Council, and to every volunteer, to every worker, I give them a copy of that. And then as questions arose, then those would be taken up by the team, the committee that is organizing and setting forth strategy. And so each action has an opportunity to be reviewed and avoid violating our judicial canons when it comes to being out there in the public. The folks that I've spoken to have been the Inns of Court, lawyer groups, community folks who have gathered at a coffee shop, the Republican women organizations around the state. So that gives you a sample of the kinds of folks that I'm encountering, and also some interviews with the media.
Ms. Brody?
So I have a campaign committee who is responsible, of course, for all the fundraising. An amazing group of people who is very familiar with the canons and the do's and the don'ts. I have a campaign manager. I have a terrific field director right back there, Stacy Pittman, who is amazing and helps me keep life a little bit organized. In terms of structure, I've been around the state. I've been from Port Hill to St. Anthony. I've talked to Republican groups, Democrat groups, civic groups. I've talked to law firms, businesses, basically any way that I can help get the word out. These candidate forums tonight, and then there's 2 more this week, I think are terrific opportunities to help educate the Idaho voters. And of course there's going to be written voter guides through the Secretary of State website, and also through the Secretary of State is the one that I can remember off the top of my head. But those are great voter resources.
Mr. McKenzie?
So, like Robin, I put together a committee that handles the fundraising, so I'm not involved with that. I've called Tony Cantrell 3 or 4 times as issues came up, just to make sure we were doing it right. I've been across the state, Rexburg, Fairfield, Shoshone, Gooding, Lewiston, Wallace, Coeur d'Alene, Centerville last Sunday. talking to civic groups, the Republican groups, law firms, trade organizations. We have a very early primary this year, and so I've just been trying to get out and talk to everyone that I possibly can about the election, because we have so few contested judicial races. A lot of people aren't aware of it, so it's good that we have people that are interested and show up and care enough to find out about the candidates.
I'll make my answer short because most of what they've said are the same things I'm doing. I do have a campaign committee that handles the fundraising. I don't have any association with that. It's handled separate from me. We do, with each fundraising event, provide a guidance to each person that's doing the fundraising so they know what the judicial canons require to make it clear that we are going to be in compliance with those requirements. I've been traveling around the state. I've been from east to west, north to south, trying to meet with as many groups as I can, civic groups. I've been to some of the same events, the Republican women's events, business interest groups, just anyone that's willing to listen, frankly, because you need to get out and let people understand who you are and what your purpose is for running. So.
Mr. McKenzie, this question from the audience: why are protecting the constitutional rights of criminal defendants important to the people of Idaho?
That's a good question, and it's important to protect the rights of everyone, and it's most important to protect the rights of those that are most vulnerable to having those rights trampled on. You may have heard presidential candidates from both sides say, we have 5% of the world's population, but 25% of the world's prisoners. And it's important that people that go into the criminal justice system have the constitutional protections, whether the Idaho State Constitution or the U.S. Constitution. The work that we did on the Public Defense Reform Interim Committee, I think, was important work, and it's work that will continue. I think from the legislature, they'll do their role, but also from the judiciary. From all the way from the Supreme Court down to the specialty courts, which we've got great specialty courts in the state of Idaho. Those are very important. And so what I would say is I'm always proud to protect people's rights as they go through the criminal justice system, and we need to always be aware of how important that is.
Mr. Strong?
The criminal justice system is important for several reasons. One, in order for the public and the individuals to have confidence in the judicial system, they have to know that the Constitution is being applied in a fair and equal fashion to all parties. And under our laws, under our Constitution, indigent defendants are entitled to a fair and equal representation. And we certainly have challenges in Idaho with regard to our current criminal defense system. The legislature took some important steps this last session to begin to address those issues, but more needs to be done. But at the end, if people are going to have confidence in the system, they have to know that everyone is being treated in an equal and fair fashion, consistent with the Constitution and laws as written.
Judge Gutierrez, the question is about protecting the constitutional rights of criminal defendants and why it's important to those of us who, in my case, I hope never to be a criminal defendant.
I think I view it as opposed to targeting a group, is that we as judges are sworn to uphold the laws of this country, including the Constitution, and therefore it's not about protecting someone's rights, but it's really about, as judges, upholding the law that we are responsible for, including, as I said earlier, that goes to the integrity of our court system.
Ms. Brody?
We are truly spoiled. We do not understand the incredible role that the rule of law plays in our society. We take it for granted. We take for granted that people will stop at stop signs. I lived in a country where the rule of law didn't exist. I was in Russia between 1992 and 1993 when Yeltsin had just taken over from Mikhail Gorbachev. And living there, it was a whole different experience where the police would pull you over at random just because they wanted to know who was in your car and what you were doing. And they'd pull you out at gunpoint and search your car and question those who were in it. There was no rule of law. And I think in order to preserve the system of government that we have to uphold the rule of law for everyone. And sure, it creates tension and conflict and difficulties. You know, I've seen it in my own practice, working with people who have been the victims of crimes. It's so difficult to look at them straight in the face and say, this is why the rules exist. It's to protect all of us. That's why I think it's important to protect the rights of criminals.
We all know that a major part of the responsibility of being on the Supreme Court is hearing cases, deciding cases, writing opinions. But several of you have alluded to other responsibilities that go along with sitting on the state's highest court, administering the justice system in Idaho. Mr. Strong, what, from your perspective, is the single biggest challenge facing the Idaho judiciary?
I think the single biggest challenge is in restoring public confidence in the judicial system itself. One thing that I have seen as I've prepared for this particular debate and for running for the court is that we see the public turning away from the court primarily because of the cost and time associated with trying to pursue a case. What we see are a lot of litigants turning now towards mediation as an alternative solution. And in some instances, that may be the right solution to pursue. But the consequence of mediation is it's done in private. It doesn't create the precedent that is useful in helping to resolve future disputes. We need a body of case law that addresses 21st century issues so that we can avoid future disputes. And if we don't get the process turned around to where we can get people to the point that they can afford, anyone can afford to come to the court and get relief, we run the risk of losing that body of case law that we need. And I think ways to do that are, one, looking to try to triage cases. Not every case has to be litigated to the ends of the earth. Some of them are simpler cases which we could have a streamlined process for. Other cases are ones in which we don't need to have the extensive discovery. For example, one option we might consider, and is one that's being used in the family law context now, is requiring initial disclosures. By having those initial disclosures, parties will be better prepared with their case to be able to evaluate whether it's one that should be settled or pursued. So those are the kind of things I think we need to do. One is to restore public confidence in the system by making access to the court affordable and timely for the litigants.
Mr. McKenzie, question about the biggest challenge, more from an administrative standpoint, facing the courts.
I think it's ensuring our judges don't have an overwhelming caseload, getting candidates that are qualified and have proper experience, and continuing to develop our specialty courts, veterans courts, drug courts, domestic violence courts, those kind of things, I think are all our three probably the top priorities.
Ms. Brody?
From my perspective, it's surely the implementation of the new computerized court system. Getting all the counties up and running, I think, is an enormous task. The resources are slim, and in terms of dollars and people, and frankly, you've just we're bumping up against mindsets and challenges of people's resistance to technology. You know, I know in my own practice, when I became a solo practitioner, I was super spoiled from the Hepworth firm. We had every resource available. I mean, I had secretaries, paralegals, all kinds of help. But in the solo world, I quickly discovered that technology could really transform my practice. And I've worked with Gary Allen and Jonathan Fishman over at Lean Law to really make a difference in my practice. And now I've got my iPhone synced with my laptop and synced with my desktop and my computer at home, and I can stand at Disneyland and push a document to my client in an emergency, you know. And it's an amazing, technology is an amazing tool, and we've got to get it implemented in a timely fashion before the system that we've started will be out of date. And I think that's a big task for the judiciary.
Judge?
I would say it has to be the access issue. As the cost of litigation, the cost of hiring a representative has gone up, many folks it's not a question of reducing costs, it's a question of not even believing that they can come through the doors of our court system. And Chief Justice Jim Jones has spearheaded the pro bono efforts around the state, but the need is much greater than that. And there's other actions that have been taken, and I think really the court has to take that on and put forth a strategy that will allow the doors of a courthouse to be open to everyone.
In Washington, D.C. right now, we're seeing some would say an unprecedented situation with a vacancy on the Supreme Court, which by all appearances is going to remain vacant for close to a year, if not more, with the death of Justice Scalia and no desire on the part of the majority party in the Senate to consider a replacement prior to the election this fall. I want to ask each of you if you see a danger in this partisan politicization, my term, of the federal courts. And is there a danger that partisan politicization of the courts could seep in to the Idaho courts? Judge?
It is a real threat. You know, we've had what I would say the threats to the independence of our judiciary come in many forms. You know, as a trial judge, it was sometimes the direct threats on criminal cases or somebody who was upset, sometimes the harassment by filing of lawsuits against judges. But I think the greater threat is both the politicization of the judiciary and big money having a greater impact on judicial races. And it will come to Idaho. It's just a matter of when.
Ms. Brody, do you see some dangers here?
I don't think so. The U.S. Supreme Court has been through these sorts of tumultuous times before now. And I believe that is an enduring institution that will weather this political storm. I don't see the type of polarization or the political issues arising here in Idaho at all. In fact, I think our system is quite a bit different. And at least, you know, I think these campaigns and this process that we're in right now is exactly what our forefathers were thinking about. And we don't have huge outside dollars flowing in, and I just don't see that there's any reason at this point in Idaho's history to worry about the things that are going on in the federal system.
Senator, the question is about the danger, if there is any, in the judicial branch becoming just seen maybe by the public as being another partisan branch of government.
Well, as you say, it's a completely different process. And I think in addition to the U.S. Supreme Court, I thought I saw there's like 78 federal positions open. And I don't know if you have cases here on the federal bench here in Idaho, but things are slowing down, and hopefully we will get a position filled there. But we have a different process. We elect our justices, and we do it in a system through those judicial canons and other limitations that tries to take the partisan nature out of it and have candidates run basically based on their experience without getting into specifics of things that would come before them on the bench. And I think if you look historically at who we've had on the bench, I think we've had good justices that reflect Idaho, and we don't run into that same problem where you have a Senate that's not going to either hold confirmation hearings or not vote them out of committee or not vote it off the floor, which has happened at the federal level, over 2 centuries. They've had that situation. We just don't have that here in Idaho.
Well, looking at the federal level, and even at the state level, there's always a tendency or a risk that there will be efforts made to try to politicize the process. But I think if you look historically at the United States Supreme Court, oftentimes people think that they have appointed a justice that is either liberal or conservative, and it turns out to be something else. On the state level, I think we've got safeguards in place that make a lot of sense. The safeguards being that if we go through the appointment process, we have the Judicial Council that can screen candidates, which is a very good process, one that I went through back in 2007. So that's a way of ensuring that from the appointment process that the candidates that go forward to the governor are qualified. In the election process, I think the rules that we have in place about not talking about issues coming before the court, not being involved in the fundraising, are ways of separating that effort to politicize the court. And I think in the end, you can never prevent all politics, but I think we've done a pretty good job of trying to minimize it and ensure that we get the right candidate to the court.
And Senator McKenzie, are there some things from your perspective that the Idaho court system could be doing to better serve the victims of domestic violence?
A few years ago, we put into the Constitution rights of victims. And so when you handle criminal cases, prosecutor on the defense side, you always take that into consideration and make sure they're notified. I think it's important that we continue to invest in domestic violence courts. We need not just to address the issue of punishment, but rehabilitation and try and protect people in a relationship. And so, we've got domestic violence court. We make people go through each of the steps. It's a long process, usually a 52-week process to go through that. I think it's effective, and I think it's been a good tool.
Mr. Strong?
Well, as Deputy Attorney General, my job has been to litigate on behalf of five separate agencies, and we work in almost all areas with the exception of domestic relations. So this is not an area that I have particular expertise in, but it's one that I've looked at, and it's one that is a significant concern to me. So if I were appointed to the court or were elected to the court, that would be an area that I think is important for us to continue to see if there are better ways that we can eliminate or reduce the amount of domestic violence, but I don't have a particular recommendation at this time.
Ms. Brody?
I had the pleasure of touring the FACES Center here in Ada County with one of the Ada County prosecutors who's in charge of that facility, and it is an amazing, amazing resource. To have in one place, all under one roof, the resources that are there. You've got everything from medical staff to counseling staff to social workers to police to the attorneys who are going to be handling the cases, so that when a victim of domestic violence or child abuse or some other elder abuse, some other form of abuse comes in, they're all right there under one roof. And the care for that particular person or family that comes in is all coordinated. I think it's an amazing model, and one that if we could use that model and get it implemented in other places would just be, I think, fantastic for victims of whether it be domestic abuse, child abuse, elder abuse. It's a terrific resource.
Judge, the question is Are there better approaches that the Idaho courts could adopt to dealing with these domestic violence victims?
I would agree with what Ms. Brody said in the sense that I know we have one in Nampa. I think they call it the Family Justice Center, that is comprehensive in its response, immediate response to the needs of domestic violence victims. I think what I would see as something that needs to be added to that is that we have some parts in our community where there are cultural barriers, language barriers, and we really need to be able to reach out to them so that there is protection for anyone who is a victim of domestic violence.
Over the last 12 or 15 years, the Idaho Supreme Court has placed a considerable amount of emphasis, I think it's fair to say, on the development of these special courts, drug courts, mental health courts, even courts to deal with specific issues related to veterans. From your perspective, are those successful? What have you experienced in seeing success with drug courts, for example, or mental health courts? Judge?
I was fortunate to be part of a team in the 3rd District to establish the first drug court. And it was interesting how it all came together. There might have been the thought that there would be elements within the legal community that would be opposed to it, but actually once you begin to study, you realize that it's of great benefit to the community to invest in what we call problem-solving courts. And so we began here in Ada County, and now they're all over the state, and they do have their specialty areas also including for juveniles. The reason why not only I, but the legislature has spoken in support financially of all of our problem-solving courts is because it's a comprehensive approach to addressing the needs of individuals. And as a district judge, I remember being frustrated with the fact that it seemed like the only tool I had was to send someone to get incarcerated. When you have a group of professionals who are working with these individuals, providing a support system and holding them accountable on a daily, on a weekly basis, the results are much better for those folks and, of course, for the citizens.
Ms. Brody, what's your view on these problem-solving courts?
I think it's a fantastic opportunity for families in our communities, and certainly talking to judges, even the grumpiest among them, they're often very favorable. They're very much in favor of these courts and really see a lot of positive things coming out of them.
Mr. McKenzie?
Yeah, I've sat in hours of drug court, most here in Ada County, but in Canyon County. You see the judges, the prosecutor, the professional staff invest a lot of time. Sometimes they volunteer their time for this. Sometimes it goes in the evening, and it can change lives. You find when people, when they're ready to deal with an addiction, most people don't have the tools. They're in the wrong environment with the wrong people. But drug court takes them out of the jail or possibly prison, and it puts them through the structured program. And it's very structured. It's not an easy program. A lot of time, most people are going to spend some time in jail doing the sheriff's inmate labor detail, working community service, because they're going to relapse as they go through it. But it does change people's lives. It has an amazing effect. And it's the same thing for mental health court. Prisons are not a place where you can get mental health treatment like a lot of that population needs. There's a lot of dual dependency, mental health and drug issues, and it's a unique population that we can deal with in specialty courts. Same thing with Veterans Court. We have a lot of military that have served, that have issues that are unique to their service. They come back and often have trouble with the law because of PTSD or whatever. And it's appropriate to put them into Veterans Court or a program where we're not just going to lock somebody up. We keep them with their family, we keep them with their job, in their community with their support structure. And it does change lives, and I think it's one of the tools we need as a state going forward, not just to deal with caseloads, and not just to deal with incarceration and the crowding of jails and prisons, but also with how we treat people and how we want to help them be able to move forward with their lives.
I think the specialty courts are the very types of innovation that we need to restore public confidence in the judicial system, in the sense that we are tailoring the needs to the particular issue. Rather than incarceration, we're finding ways to rehabilitate folks. And this is one that I have a personal interest in, and that I have a family member that's actually been through that process and is now a productive part of society. So I'm very much in support of those types of courts.
Each one of you, in one way or another, has described the importance of restoring confidence or keeping confidence, public confidence in our judicial system, providing access to the courts. We have a couple of members of the Fourth Estate here. I'm just wondering, as a judge, how would you view the role of explaining the working of the court, including particular cases and how they were decided, to people like Betsy Russell, for example, so she can relay that information to the public at large? What is the role of a judge in interacting that way? Ms. Brody?
I know in sentencing decisions, particularly, I think the most effective district judges are those who can look at both sets of families, recognizing that any time a crime takes place, you have, of course, the victims of the crime who are impacted, but you also have usually a defendant and his family or her family that are also impacted by the decision making. And I think anytime a district judge can look at both sets of families and look at them squarely and articulate exactly why she's making the decision that she is, I think it's important. I think it's important. I believe lawyers are heroes. I believe what we do is good stuff. And I'd love to shout it from the rooftops. I mean, I look at our legal system today, and it makes me sad when you go to high school graduations and the kids go around and say what they're going to be doing when they graduate, and you'll hear doctor, engineer, computer technology, but rarely do you hear attorney. And look at the newspaper article just that came out yesterday in the Times News about the declining role of, or the declining enrollment in law enforcement programs, for example, at the College of Southern Idaho. I think we need to be singing each other's songs. And I think educating the public and being in the schools and being in the communities and being active and doing everything we can to sing our song is really important for all of us.
Judge Gutierrez, how would you answer that question? Do you feel some responsibility, or would you feel some responsibility on the Supreme Court to explain the court's actions more broadly?
I think as part of our American society, it's important to always have government that is transparent, that is accountable. And so the media plays a very important role in that regard. There are challenges that are always presented. I know there's been changes within the print media, and sometimes they may send someone to attend who may not fully understand the process, and you may get a picture from reading the newspaper that maybe leaves out some of what actually is intended to be conveyed to the readers. And so I think the courts, not only at the Supreme Court level, probably more important at the local level, need to be working with the media so as the information that is relayed to the public is accurate, and that the public remains informed of the workings of the court.
Mr. McKenzie?
I would say, most of the people, the vast majority, are going to interact with the courts at the trial level. When a case comes before the Court of Appeals or the Supreme Court, most times people are going to have an attorney who's experienced, who's guiding them through the process. And a justice is going to be fairly limited on what they can talk to the media about with respect to decisions. I think the role is just to fairly and impartially apply the law. I do think outreach is important. I've always enjoyed talking with students about the process. Not pages that come through high school students who go on and are interested in public service after they're serving, but also high school classes. That's one role, but I think the Supreme Court's major role in this area of confidence from the public is the administration of justice, because the interaction for almost everyone is going to come at the trial level through the way they're treated by the trial judge, through the specialty courts, seeing the caseload and feeling like their case is going through at an appropriate pace, or that they were treated fairly, or that a victim was given proper notice and ability to talk before the judge. Those are the things that we would administer from the Supreme Court that are really going to give confidence to people.
This is an area in which I think the Supreme Court has done a really good job. They have a media committee, a media guide that's made available. It sets forth the process for judges and for the appellate courts to allow media access to court proceedings and court records. Those guidelines are such that they try to provide the maximum amount of transparency while at the same time protecting private interests or rights, such as confidentiality, the attorney-client privilege. And the other thing that I see happening right now is with the Odyssey system, an effort by the court to reach out and to try to make all records transparent, available to the maximum extent practical. So between the media guide and the efforts of the court to make public access available electronically to documents, it seems to me the court is on the right track, and we just need to continue to pursue that track.
Well, thanks to each of you for the questions and for your questions. We didn't quite get to every one that was submitted, but I think we got a broad representative cross sample of your questions, so thank you very much.
Thank you, Mr.
Clay?
Your great question.
Thank you.
Your service on this forum.
My pleasure. Thanks.
We're now going to move to the closing statements of each candidate. We're going to go in reverse alphabetical order. Each candidate will be given 3 minutes to make their closing statement, and now the orange cue card will be 1 minute long.
It's a real challenge for an attorney to conclude in 3 minutes, so I'll get to the issues that I think are important. As I said in my opening, I think this is an important election, one that it's important for the public to become informed about the qualities and characteristics and traits of the individual candidates, because the next justice that's going to serve on the Supreme Court will be making decisions that not only affect you for the next 6 years, but far into the future as precedent as we move forward. So in that respect, I come back to the qualities and characteristics that I think set me apart. Set me apart in the sense that I have had the privilege over the last 33 years of serving the 1.6 million people of the state of Idaho. Those have been my clients. And as my clients move to the Supreme Court, those would continue to be my clients. Those would be the ones I'm accountable to. I'm not accountable to any special interest or any agency, but just to the people of the state of Idaho. And I would look to establishing trust and confidence with the public by demonstrating that I'm fair, impartial, honest, diligent, exercising careful judgment, looking to the best interest of the state as a whole. And I would do that by the way I approach people in the courtroom, making sure that every litigant who comes before the court has an opportunity to present their case and feel like they've been heard, and to understand that even if they're not on the winning side, why the decision was made the way it was, so that they can have confidence that the decisions are made in a fair and just way. I would work to make sure that from the administration of justice side that we would try to make an open process for parties and litigants to be able to understand how the court operates, to make sure that we are taking steps to address access and accountability in the court system itself through further development of the Odyssey system, for example, and working with individuals to look at ways that we can streamline the process so that it's more accessible to the public. And those would be the actions that I would take as a justice on the Supreme Court, and I would ask for your vote as we go forward. Thank you.
Thanks, Clayton. Again, I think it's important to have a justice who's had a diverse practice, both in the types of firms that worked with, but in the caseloads that they've done. I've had civil, criminal. I've worked with large law firms all the way down to a sole practice. Done civil rights litigation, criminal practice, both representing the state and representing individuals, as well as worked on complex civil litigation. I think that's an important background to have, as well as a history of public service, not just the legislature, but in the community, trying to help families redirect their lives, or at the Syringa House with those young women getting their life back on track, or representing our region and trying to develop the economy of the Pacific Northwest. I think those are all unique things I could bring to the bench, and I think it's important to have that diversity of background on the bench as we go forward. So thank you.
Justice Gutierrez.
I'm a judge, not a justice yet, but I appreciate sharing the platform with some great lawyers. In full disclosure, I guess we ought to tell them, Senator McKenzie, that we raised our kids, our grandkids, and going to the same church, and so we're both from Nampa and know each other pretty well. I'm not a good salesman when it comes to myself. And I would say, don't go by my word. Go by those folks whom I've worked with. Go to those folks that I've helped, beginning with legal services and my time with them, working on behalf of farm workers, being recruited by a firm in Boise to come and work with them, specifically with the idea that I would be expanding their ability to help the larger community of Latinos that's up and growing just tremendously in the state. We have some school districts where 50% or more of the students are Latinos. We have also an interesting thing happening with regard to our two cities that are refugee cities. About 1,200 or so refugees a year being settled to our state, and so we need to be able to respond as a court system, respond to those needs. Also, I've operated a solo practice, and I share the experience of at times not having to pay myself to pay my employees, but I was able to quickly, I had planned for 3 years to sort of be at a level that would help me put food on the table at home. But it was within a year's time. I think that speaks of the kind of work that I did as a private lawyer. And then what can I say about the appointment by two different administrations, Governor Cecil Landis, Governor Ken Thorne. I ought to mention that probably I enjoyed more of the work that I did with the First Lady, working on the Governor's Council for Families and Children. I always mention that that's my night job. And again, following the example of Justice Sandra Day O'Connor, I spent a lot of time with in our communities with youth, families, and education issues. It's something that I saw in the district court experience, that the majority of our folks coming through the criminal justice system did not have a high school diploma. So it takes, what rises out of my own experience is the judicial independence, and thank you for the red card. But please, I humbly ask for your consideration.
when I was getting ready to file the petition for candidacy, I sat down in Walt Biffle's office. And I, of course, in my usual fashion, was ready to hurry up and get everything done and taken care of. And Walt made me sit down and talk to him. And he said, you know, he said, you're about to do something that not very many people get to do. And I hope along the way that you'll take some time to really enjoy and really appreciate the experience that you're going to have. And I'm glad Walt said that to me. I'm glad he made me take the time. I have truly enjoyed going all throughout the state, meeting new people, going to places I would never otherwise go. It's a terrific experience. One of the questions that I was asked by someone really kind of set me back on my heels a little bit. He said, are you doing this because you want your little boys to see you as someone important? And I've thought a lot about that. And I thought, man, I hope not. I hope that's not why I'm doing this. What I want our little boys who are sitting back there to see is their mother doing something important. The Supreme Court has important work to do, and I'd like to be part of it. The best part of going throughout the state is seeing all the beautiful courthouses that have been built. Communities I know they sacrificed to build them. Fremont County and Boundary County, they sacrificed, and they're beautiful and they're wonderful and they endure today because the rule of law is important. I'd like to be part of that system here, and I think I have something to give after 20 years. There's a real beauty to what we do, and dignity, there's grace, and there's nobility. Margaret Thatcher once said, if you want something said, ask a man. If you want something done, vote for a woman.
I learned two things today. First, those that serve on the Idaho Court of Appeals are judges, not justices. The second is that we have 4 very qualified individuals running as candidates. It's something that Andy Brassey taught me when I first started practicing law 22 years ago. It is an honor and a privilege to be a lawyer in Idaho, and thank you all for your willingness to serve on our highest court. Thank you all.